the newspapers in the project area. Upstate submitted its application to the Commission on January 13th, 2009. They subsequently submitted supplements in April and August of 2009. The application was determined to be in compliance with our rules and regulations as of August 20th, 2009. The discovery process, which is ongoing, and that's to address questions directly to the applicant about the proposed project, is ongoing. We've already commenced discovery. Staff at the back table there has the discovery requests that have gone out and the answers received to date. You're more than welcome to take a look at it. Following this, the evidentiary phase, the trial tape phase begins. At this time, the applicant's direct case is presented. Other parties may present their direct case, and there could be rebuttals and responses to those cases. Or a proposed settlement may also be proposed.
Morning, Barry.
This is followed by a briefing phase where parties summarize evidence and their arguments. The decision phase, at this point, the administrative law judges who preside over the case may make a recommended decision. Replies to the recommended decision, including exceptions to that decision, would be submitted by all parties. This will culminate eventually in a decision by the Public Service Commission, and any appeal that to the Commission's decision must be made within 30 days of that decision. The Commission may choose to deny the application if they determine that the facility is not needed. They could approve the proposed group. They could approve it with conditions or make minor changes, including conditions to mitigate some measures, whether they be environmental or different impacts. It could include an alternate location, alternate design, underground locations. So there are different options that the Commission has in making this determination. In making a finding, the Commission is required to make several findings by law. They must look at the basis of the need for the facility, the nature of the probable environmental impacts. They have to show that the group minimized adverse environmental impacts to agricultural lands, wetlands, parklands, and river corridors, and giving consideration to costs and alternatives at the same time. They look at what part, if any, shall be underground, that the project is in conformance with state and local laws and that the regulations, and finally, that the Commission must find that the facility will serve the public interest, convenience, and necessity. This reflects a typical case proceeding. It goes through alternate group identification, if any, pre-filing direct testimony by staff and interveners to active parties, pre-filing of rebuttal testimony to all parties participate in that as well. Evidentiary hearings, site visits will be conducted for all groups suggested. Initial briefs, reply briefs, recommended decision, briefs on exception, if any, and the Public Service Commission decision. Typically, after a decision to approve an Article 7 facility has been made by the Commission, the developer will provide detailed plans. They include surveys and right-of-way studies, environmental management and construction plans. The public is then provided the time to review